Good afternoon. Good afternoon. My name is Attorney Veronica McClendon, and I am here to talk to y'all about trust. A lot of people want to know what's the difference between a revocable trust and an irrevocable trust. So that's what we're going to talk about today. I'm just let a few people join if they want to join in, and we will get started. Everybody's talking about trust these days. And so I figured that I would come on here and talk about trust and what they can be used for. Answer a few questions, but I know that there'll be more. So we'll be having some more videos soon to talk about trust and the different ways they can be used, the different benefits to them, some of the things you might want to think about if you're considering doing a trust. We'll talk about that in the future. But today, we're going to respond to a comment that someone left a few weeks ago when I did a video about estate planning. They wanted to know what is the difference between an irrevocable and a revocable trust. And I thought that was a really great question because a lot of people don't realize that when we talk about trust, there are different types. And the two main categories of trust are irrevocable trust and revocable trust. And those are any trust that you create is going to probably fall into one of those categories. Perhaps there might be some hybrid between them. But for the most part, it's going to either be a revocable trust or irrevocable trust. And the first difference between those two categories of trust is that an irrevocable trust cannot be revoked by the grantor. So there are some exceptions to that rule, but generally speaking, the grantor, who is the person who has created the trust, the person whose property is going into the trust, if it is an irrevocable trust, the grantor cannot change it, cannot do away with it. They cannot, if they decide that they don't want to trust anymore, there are a lot of limitations to their ability to terminate the trust. And so when it's irrevocable, it's pretty much, how the name is irrevocable. It cannot be revoked. There are some exceptions. When we create trust as attorneys, we try to set it up so that if something happened that the grantor couldn't have anticipated, and they need to make sure that that trust is changed or terminated, there are some exceptions to the rule that we can put into the trust that can allow usually someone else that the grantor has appointed. It will allow that person to either change the trust or terminate the trust. But generally speaking, if that trust is irrevocable, it cannot be changed or terminated by the grantor. And the reason for that is that when you create an irrevocable trust, the goal is to take the property out of the control of the grantor so that it is in the control of someone else. That someone else is called a trustee. And the reason why you want to do that is because there might be some protection that the grantor is trying to put in place for those assets. And they don't want someone saying, well, if you can use that property the way you want to, then you can use it to give to me for whatever reason that might be. And we'll talk about some of those reasons in a few minutes. But when you take control out of your hands and put it into the hands of someone else and say, I give up all right to control this property, I give up all rights to take this property out of the trust or put additional property into the trust, then when you're doing that, then you are protecting those assets from anybody who wants to take something from you. And again, we'll talk about some of those categories in a minute so that it will make a little bit more sense. But revocable trust means that you can revoke it. The grantor can change it, they can terminate it, they can make modifications to it, they can create what we call restatements, where they basically change the rules of the trust. You can do all of that as long as you are living and in your right mind. So when you are the grantor, which is the person who created the trust and put the property into it, you can change a revocable trust at any time under pretty much any circumstance. So that's generally, those are generally the differences. One can be changed by the grantor, the other one cannot be changed by the grantor except under certain circumstances. So a lot of times people use revocable trust for estate planning, kind of like a substitute for a will. It allows them to create this structure to determine what happens to their property after they die, but it also allows them to have to do some incapacity planning, which means if they got to a situation where they're not able to handle their own affairs, they're not able to manage their assets, perhaps there's an illness or an injury that prevents them from being able to manage their own property. Under those circumstances, then their trust would be managed, the property in the trust would be managed by a successor trustee. And so the reason for creating a revocable trust is to say, if I became disabled or unable to manage my property, or after I die, I want there to be a seamless process to change the control of the property from me to someone else that I have designated as a successor trustee. So a lot of times revocable trusts are used for estate planning purposes or for incapacity planning purposes. As a substitute for a will, it gives you some more flexibility than a will does, because you create a will and it's pretty much set. And the only way to change that will is to completely destroy it and create a new one. Or you can create a codicil, which we don't really do as much anymore, but that is an option. When you have a trust, it gives you flexibility to put things into the trust, to take things out, and you can create a restatement of the trust if you need to modify the actual way that the trust is structured. So, revocable trust, usually a substitute for estate planning, usually an option for incapacity planning. Irrevocable trust, the purpose is to take the control of that asset out of the hand of the grantor so that someone else can manage it in order to protect those assets. So we talked about that already. Let's talk about some specific examples. So one example would be if you are in a place where you know that you might need to go into a nursing home at some point, and you might need to apply for state benefits to help you pay for that nursing home. When you create a trust specifically for that purpose, an irrevocable trust, you are taking the property out of your name and putting it into a trust and basically saying, I don't have any rights to that property anymore. I can't touch that property anymore. I can't control what happens to that property. I have delegated that authority to someone else. So, for all intents and purposes, I don't own that property. And why that matters is because when you are applying for needs tested benefits such as Medicaid, then they're going to look to see, do you have any income? Do you have any assets above a certain level? If you have put those assets into an irrevocable trust, then they are outside of your control. So for all intents and purposes, you don't own those properties anymore, and they can't use it to determine your eligibility for Medicaid or other state financial based benefits. The thing to be very careful about there is that there's a time period within which, if you transfer your assets into the trust during that time period, and then you need to apply for Medicaid or some kind of financial benefits to help pay for your nursing home care, then there's that look back period where you could be prohibited from accessing those benefits. And so you have to be very careful to plan enough in advance that you don't put yourself in a situation where you don't have the resources to pay for care if you needed it. So that's definitely a one-on-one attorney client conversation that you would need to have in order to make sure that you protect yourself. Another reason why someone might want to put their property into an irrevocable trust is because they have that they're engaged in some kind of business where they're high risk and people want to sue them. So think about a surgeon or someone who owns a trucking company. There's a lot of potential liability there. If someone gets injured, they could sue you for millions of dollars. If you want to protect your assets from those kinds of lawsuits, you might consider putting it into an irrevocable trust, because let's say someone sues you and they say, oh, this doctor got millions of dollars of properties and they have bank accounts and they have these various things. I'm going to sue them for all of that. If you put it into an irrevocable trust, it can be protected from those kind of lawsuits. And so sometimes people will put some of their property into those asset protection trusts so that they can preserve them for whatever reason. They might say, this is for my kids, it's for my wife or my husband, this is for my grandkids. I don't want anybody to be able to touch that money if I were to be liable for something. So that's again lawyer client conversation. You got to make sure that you do it in the right way so that you don't put yourself at risk and so that you don't break the law. There are some ways you can break the law by creating these trusts. So you want to make sure you're careful about that. Some people, when they are at a level of assets where they might have to pay an estate tax at the end of their lifetime, those situations, that might be a reason why someone would want to create an irrevocable trust. Because again, when it comes time to look at what is your tax liability for your estate, they're going to look at what property did you own when you died, what income did you have, or what assets did you have. And if those things are set aside in an irrevocable trust, then they are not able to be counted for those death tax purposes or the estate tax purposes. So those are some reasons. Another reason would be if you have a loved one who has a disability and you want to make sure that you provide for them financially, but you don't want them to lose their eligibility for needs-based benefits. So for example, you might have a loved one who has a disability and you know that even though they're an adult, they'll never be at a place where they can live independently. And you know that they are going to need to rely on public benefits for the rest of their life to pay for their health insurance, to perhaps pay for some of their living expenses. But you still want to leave something to them. It's not enough to set them up for life to where they don't need any state benefits, but it's at the same time, it's enough money that if they received it, then they would lose eligibility for those benefits. And so in that case, you might create an irrevocable trust for those assets so that you can provide for that loved one while not disrupting their ability to receive social any kind of SSI or Medicaid or any kind of needs-based assistance. And so in that case, you would again have a trustee who receives the money, pays any expenses on behalf of the person who is benefiting from the trust, but the person benefiting does not have the right to use the money for whatever they want to. And so those kind of trusts are often used for, so let's say their living expenses are covered, their medical insurance is covered, but they might need some special medical care devices. Or you might want to let them go on a vacation or get a special gift that they can enjoy that you want them to be able to get using that money. And so that's why a trust like that might be created. And there are so many other reasons why people might create irrevocable trusts that I can't get into today, but it's always a good advice to talk with an attorney about any concerns that you may have to see what kind of trust would be best for you if a trust in fact is good for you. Some people also look at trust for just like capital gains tax planning and preserving family wealth, trying to they want to make sure that their different family members are getting what they need but are not able to squander the money. So you give somebody $100,000 and say have fun. There's a difference between that, giving them that money outright versus giving it to them in a trust where you are saying that you can have access to this money but someone else is in charge and you can't just use it for whatever purpose you want to use it for. So people use trust for different reasons. I mentioned the different types: revocable, irrevocable, and those can be broken down into other categories for specific purposes. But I wanted to close, before I close, I wanted to make sure that I was clear about how a trust is structured. So a trust is a legal entity that's created to hold property that someone else owned, but it's for the benefit of other people. Sometimes the person who created the trust, as I mentioned before, the grantor, will be the person who is benefiting from the trust assets. But in most cases, it's going to be a different person. So you have your grantor, that's the person who owned the property. They set up the trust and they put their property into the trust. Then you have the trustee, who is the person responsible for managing the trust and making sure that those assets are protected invested properly, and distributed to the people who are entitled to those assets. And then you have the beneficiaries, which are the people who are benefiting from those trust assets. And so the trustee is managing that property for their benefit. So you have those categories, and I wanted to make sure I was clear on that so that you can kind of understand how a trust works generally. Let me know in the comments if you have specific questions that you would like me to dig a little deeper into, because my goal here was to kind of introduce the topic, and we can talk more specifically about different subtopics that might be of interest to you. Just let me know in the chat. And I am Veronica McClendon, the CEO and managing attorney of McClendon Law and Consulting. It's been a pleasure talking with y'all, and I look forward to the next time. Y'all take care.